Good morning. I know you've had a bunch of speakers before me. If anybody wants to, while I'm talking, if anybody wants to stand up and stretch, it's perfectly okay with me. I'm going to be talking just for a few minutes, briefly, about three items. What we call powers of attorney, advanced medical directives, and often referred to as living wills, and wills. And I'm going to, because of the short time, I'm going to talk about the simplest from a standpoint of understanding what these concepts are first, and that would be the advanced medical directive. It's got a long name. It's called a general durable medical power of attorney and advanced medical directive. What that is, that's an animal that has been created by statute by the Virginia legislature that most people refer to as a living will when we're talking about it on the street. And basically the document says that if I have had a catastrophic illness or accident, I'm being kept alive solely by heroic equipment or machinery, and at least 2 doctors have said that there's no hope of any recovery with any dignity of life for me, that I don't want to survive that way. I want the plug to be pulled. That's pretty standard. I would say that about 99 out of 100 or 99.5 out of 100 of my clients want that particular document. So it's a pretty standard document that we use. It's not talking about when you have a headache one morning. We're talking about serious situations where you're comatose, which means you cannot tell the doctors or tell your family what you're thinking or what your thoughts are, what your wishes are about your welfare. You have decided that up front and said, I do not want to be kept alive solely by heroic measures and equipment just to keep my heart beating or my breathing going, that I don't want to survive like that. The second document is a power of attorney, and that I refer to as a financial document, a financial power of attorney. And what that says is that you've decided to appoint someone that you have a great deal of trust in to care for your financial needs and your financial welfare if you can't do it, or if you just simply get tired and don't want to do it. So you're saying, I appoint my son, my spouse, my daughter, my friend, someone that you have a great deal of trust and confidence in to take care of your personal financial affairs, to deal with your banks, to deal with your investment companies, to deal with whoever you might need to deal with from a financial standpoint. You appoint that person or those people to do that for you. The test I use is, if in determining who you would appoint, is if you needed to leave my office or this building right now, if you need to leave this building right now, couldn't go home and get a toothbrush, you had to leave and be gone for 3 years, and you came back, would your financial affairs be in as good a shape as you could hope for them? And that doesn't mean that your power of attorney can't make mistakes, but it does mean that you trust that person to do what's best, not for that person, but to do what's best for you. So that's the test that we use. If you had to leave today for 3 years, would you come back and say, hey, you know, he or she did a pretty good job. It was okay. They did the best they could for me. So often, the power of attorney has been misconstrued by folks who don't understand it to think that that is giving someone control over your life. That is absolutely not the case. So the key then to avoid that type of situation is not to appoint someone you don't have complete full trust in. So I say find that person, and if you can't find that person, if you really don't have anybody that you have that type of trust in, then go to the opposite extreme and appoint someone like a bank or trust company that has to, under the law, do exactly what they're required to do, and they know what those duties are. Yeah, they're entitled to a fee for doing that, but it's better to have them do what's necessary for you than to appoint someone you're unsure about and not have that person perform as he or she should. So that's basically the power of attorney. It's a document you sign. You can revoke it anytime you want to, as long as this is working okay. You can change the advanced medical directive the same way anytime you want to, as long as you're mentally competent to sign a legal document. Mentally competent to sign a legal document. Has nothing to do with your physical ability to sign. We're talking about mental capacity there. That segues us into the will. The two documents I just talked about are documents that live and die with you. The power of attorney and the advance medical directive are both documents that cease to exist and cease to be when you pass away. When you die, those particular documents are finished. The power of attorney, the person who is named the attorney in fact in your power of attorney has no more authority after your death. The person who has named your agent to talk with doctors after your death, obviously that document's not needed, so that person has no more authority. So then we come to the third document that we want to talk about, and that's the will. Your will is a scrap of paper and means absolutely nothing until you die. Your will is a scrap of paper, means nothing until you die. When you die, your will comes to life and tells the world what you want done with your property. Now that can be tangible property, which is tables and chairs and knives and forks and anything that you might pick up. I like to say guitars and other things like that when I talk to my clients. But it can be anything tangible like that, or it can be intangible. Cash, CDs, IRAs, 401ks, things money equivalents, cash equivalents. So any kind of property, and then the third type of property that we generally talk about is your real estate. Your home, other properties that you might own, such as real estate in another area, another state even. So your will addresses all of these items, and we have specific provisions in wills which say, I want such and such to be done with such and such items. Then we go on and have what I call the bucket provision, and that is the residuary clause, which says everything else that I haven't addressed, everything else that's left over that I haven't talked about, goes in this bucket and goes out to someone or some people. It's easy. It's fairly easy to make the will if you have a family that you know you want to leave things to. It becomes difficult sometimes when there is some sort of distress in the family. We have situations where parents and children are estranged. We have situations where spouses are estranged. We have situations of divorces. I mean, all those things are not uncommon at all. And you have to address those things in your will, because if you choose not to make a will, the state of Virginia will make one for you. It simply says you're dying intestate, I-N-T-E-S-T-A-T-E, which means you're dying without a will. And if you die without a will, the state in the statutes of Virginia says here's what happens, and tells you basically what they think the common sense would be that you would want to happen had you made a will. But you know, that doesn't fit. That's not a one-size-fits-all situation. So it's very significant that you do make a will to determine exactly where you want your property to go, how you want it to pass. You also want to establish an executor. That's the person, the fiduciary person, the person in a position of trust, much like the power of attorney person that we just talked about. You want to establish an executor to carry out your wishes, and there again you want to name someone that you feel confident will do what you want and what your thoughts are and knows you well enough to do that. Or someone who is totally, completely separate and apart from you, if you don't have anyone like that, who will do exactly what the law tells them to do based on what your wishes are in your will. So those are the high spots that I want to cover about the will. We have a provision now that the legislature passed some years ago, which I think is really good. I call it the make a list provision, and the statute in Virginia now says that in the event that you desire, it doesn't say you must or shall or will, but it says you may, if you desire, you may have a provision in your will that says you may make a list of tangible personal property. Those diamond rings and bracelets and guitars and things like that I talked about a few minutes ago. You can make a list of whom you'd like those items to pass to. And you're asking the will that your executor carry out those wishes. So kind of the nice thing about that is that list can be dynamic. which means you can change it whenever you want to. And it also is something you can do at home. You don't have to do in the lawyer's office. We really don't even want to see the list because it's something that you can do and change, again, as long as you're mentally capable of doing that. For example, let's say that in that list, you leave your Gibson J65 1958 guitar to me. And 6 months from now, you get mad at me. Well, you just strike my name off the list and put Sam's or Bill's or Joe's or Sally's name on the list. Let's say that 6 months from now you don't get mad at me, but you give that guitar to Sally during your lifetime. Then when you pass away, I come to pick up the guitar because I know my name's on the list. Well, the gift that you made to Sally of the guitar during your lifetime trumps the list. In other words, that takes precedence over my rights to the guitar because it's already been given away. You made that choice during your lifetime. You just didn't get around to changing it on your list. So those are the areas I wanted to cover. Usually I take about an hour with clients when they come in and we sit and talk about lists. We talk about taxes and we talk about all sorts of different things. And I'll just, before I stop, I'll just briefly talk about taxes for a minute. But I want to be available, and I know we're trying to catch up a little bit and get back in time. I want to be available after I stop talking to talk with you personally about particular questions that you might have or you might have generated or I might have generated by talking about what I'm talking about today. So I'll make myself available back here for a few minutes during the break while we're, not for a few minutes, as long as you want to talk, I'll stay back there and talk in the back. Let's talk about taxes for a minute. Everybody gets a little concerned about that, obviously. And the four type of taxes that we're most concerned about on death are one, federal estate taxes. Federal estate taxes. And as right now, under current federal law, there's a $5 million threshold for federal estate taxes if your estate is not $5, so it doesn't affect most of us. We don't generally have federal estate taxes that we have to worry about. We don't know what Congress is going to do with that law. It's kind of constantly under concern or a matter of concern for Congress. So you know, you have to stay tuned to that. But most of us feel like we can't imagine that threshold would go below $3.5 million. So again, it doesn't affect most of us. We don't have to worry with that. So federal estate taxes, generally I say don't worry about it. Virginia inheritance taxes basically piggyback the federal estate taxes, so we really generally don't have to worry with those either unless our estate's over that $5 million threshold. The third type of taxes, this is the one that most people are concerned about, is income tax. And it's very important for you to understand that there is no income tax on an inheritance that your beneficiaries receive. Let's use an example. Your house is worth $150,000 and there's nothing, let's just pretend there's nothing owed on it for right now. House is $150,000 and your son or daughter inherits that house because your will says I'll leave it to my son or daughter. Then there, on that $150,000 that it's worth at the time of your death, that establishes the basis for income tax purposes going forward for your son or daughter. So if he or she keeps the house for a few years and sells it for $160,000, he or she pays taxes on $10,000, not the $150,000. $150,000, they get what's called, your kids or your beneficiaries, not just your kids, your beneficiaries, whoever they are, get what's called a stepped, S-T-E-P-P-E-D, stepped up basis. And the basis becomes the value at the time of your death. And that's true of all your assets, except, there's always an exception, as you know, when we talk about law, except if the asset was created by dollars that had not been paid tax on. In other words, if you had an IRA or 401k or something where you put money in that was pre-tax and that asset then was passed on to your loved ones, then if your loved ones didn't roll that over and continue that as an asset of the same type that you had and took it out as cash, they would have to pay taxes on that as you would have had to if you just take the cash and put it in your pocket when you earned it. That's not terribly confusing, and I see Barry's in the back here. He's probably saying, Doug, that's pretty simple, and it is fairly simple. But, and obviously there are other details you can get into, but basically, most of us don't have to worry about federal estate tax, Virginia inheritance tax. We do need to understand income taxes and the fact that it doesn't affect most of the inheritances that your loved ones inherit. And then the fourth tax that we want to talk about is probate tax. I generally am not concerned too much with probate tax either, because it's only $1.33 per $1,000 of your estate. So if you have a $500,000 estate, we're only talking about between $500 and $600 for probate tax. So it's not a planning tool. We don't try to plan away from probate tax. If your estate exceeds the thresholds for estate tax and inheritance taxes, then obviously you need to do some planning to take the maximum benefit of deductions and exemptions that you do have under those laws. How are we doing? We okay? I think rather than getting in more detail, I'm going to wrap it up with those comments, and again offer to you that I will be available in the back of the room here during, this is break time coming up, is that right, Lynn?
Yes.
Break time's coming up, so I'll be back here in the back of the room. Be glad to talk with any of you, or I'll come around to the tables if you'd like. So thank you for having me. I hope this little touch of wills, powers of attorney, and advanced medical directives have helped. Remember that it's significant to do that. I don't want that to sound like a sales pitch, but I think it's significant for you to do that, because you can determine exactly what you want done with your property and who you want to handle it. You don't have to rely on the state of Virginia or any other relatives who you might not want to come in and have a say, having a say. So it's your plan, it's your definition, it's your determination. Please make sure you take advantage of that. A will is the most personal legal document that you or I can do. It's so personal because it depends on exactly what you want, not what the law says somewhere. Thank you for having me. I appreciate it, and I'll answer any questions y'all have. Okay?